Hi guys, it's Kathy. I hope you're doing well. Michael, so that short that you found. So when I first started court watching, I was watching Law Talk with Mike. I loved watching Law Talk with Mike. It was awesome. And it got me obsessed. So I started sending him clips. Um, I would upload them to my YouTube and then send that link to Law Talk with Mike's Discord for him to play on his channel. And then people from his Discord started subscribing to my channel, but it was just my personal channel. It wasn't Court Vibes. It was my personal channel. So at some point I had to create a channel. Mike talked to me. He's like, "Hey, you can't monetize if you keep doing it like this," because all I was doing was uploading raw clips. I wasn't talking. No one was talking. He says you have to talk a bit, or you're gonna get nailed with reuse, blah blah blah, which I did. Anyway, I created a new channel. Well, when you do that, it takes everything from your personal channel and transfers it to your new channel. Everything. So I had some personal things on my own YouTube. My kids, Anthony playing football. Um, and when it came to, I'm not doing videos. I hate videos. When it came to Sophie, my dog, okay, so that short you found was my dog rolling around in poop. My dog found a pile of poop and decided to. Loretta and my boyfriend, that was James. My boyfriend was there with Loretta, his dog, and his dog was doing, dog things like catching sticks from the river. It's not a river; it's just a creek, a tiny little creek. My dog was, of course, just rolling around in poop. But when it came to, I hid all of my stuff. My stuff is still there, it's just all hidden. But I could not hide Victoria, my daughter, um, on stage because I just love that. I couldn't hide it. My heart wouldn't let me private that. And my heart would not let me make my dog private. Even though my dog is rolling around in poop, I couldn't, I couldn't private her. Um, and yeah, she's not on a leash because that's where you take dogs to play. It was this hiking trail. We went hiking a lot and we'd take the dogs and we would not leash them. No one leashed them. There was all kinds of dogs there. That's where you took the dog. He was a Marine, an ex-Marine. Like he wasn't an active Marine at the time I was dating him. He was, discharged, honorably discharged. He was also, when I first started dating him, he was a prison guard in Lancaster, but that didn't last long because those prison guards, you go to work for 8 hours, right? And then they could just tell you in the middle of the day, now you're here for 14 hours. They worked 14-hour shifts all of the time, over and over and over again. But the thing is, they didn't know it. They wouldn't know it until like they were ready to leave. They say, "Nah, no one showed up. You're working 14 hours." No, I'm not dating him anymore. he married. He married. While we were dating, but it was also going hiking with his hiking group, which I couldn't go because I had a job. He did not. And he married the one girl in the hiking group that he promised me, just annoyed him terribly. Yeah, he was dating her while he was dating me. Then he married her. But yeah, I do miss Loretta though. I do miss that dog. That dog was such a good dog. Anyway, we are going to do Georgia today. Who? Oh, the frauditor. We are going to do Georgia today. And everybody's going to, a lot of you know by now. but a lot of you are going to ask, okay? He's in here. There's this little magic box on the wall, and the voice coming from that box is what we're listening to. He's in here. No, I don't. That's gone now. My ex-husband tased him every day. Ex-boyfriends, I don't care. But this is the box. Ready? Are we ready for habeas?
So I see two amendments filed. First amendment was filed in May of 2025, and a second amendment filed in June of 2025, setting out your grounds for relief. I want to notify you, Mr. McCollum, I have reviewed those grounds, and I don't need you to just read that to me today. This is an evidentiary hearing. This is the opportunity for you to present whatever testimony, exhibits, or otherwise that you feel is in support of your application for writ of habeas corpus relief. Are you ready to proceed today, Mr. McCollum?
Yes, sir, I am.
All right, very good. Do you intend to testify yourself, Mr. McCollum?
No, sir.
All right. Do you have any evidence, documents, or other exhibits to present today?
No, just some questions for Mr. Chappell for the record.
Oh, okay. Very good. I will note that I expect Mr. Daniels has the entire record of your trial and any and all appellate decisions on your case. You have those to present as well, Mr. Daniels?
Yes, Your Honor.
And Mr. McCollum, what that means in plain English is that Mr. Daniels will admit everything from your trial and your appeal into the record today. After we get through today, you will be provided with a hard copy of all of that. And after you had a chance to review it, you can file a written brief if you so choose, if that helps you make a decision about how to proceed. Any preliminary matters, Mr. Daniels? Are we ready to proceed?
No, Your Honor. We're ready to proceed.
All right, Mr. McCollum, it's your burden. You may proceed. Do you wish to call Mr. Chappell at this time? Is that correct, Mr. McCollum?
That's correct.
All right, Mr. Chappell, please raise your right hand, sir. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, Your Honor.
You put your hand down. And Mr. McCollum, this is questions only for Mr. Chappell. Any sort of legal arguments or arguments you want to make, you make those to the court in writing after we get through. But with those restrictions, you may proceed, Mr. McCollum.
Thank you, sir. Good morning, Mr. Chappell.
Good morning, Mr. McCollum.
Okay, Mr. Chappell, you were assigned to represent me on direct appeal. Is that right?
That's correct.
Okay. And currently, well, at the time, you worked as a conflict attorney for the appellate division for Georgia.
Yes. I was, when your case was assigned to me, I was a contract attorney. So I was assigned conflict cases through the Georgia Public Defender Council.
And are you exclusively working for the public defenders?
Yes, now I am a full-time staff attorney in their appellate division.
Okay, and for the record, could you give a brief summary of your educational experience and appellate experience?
Yeah, so I graduated, or I passed the bar in 2012, I think. And when I passed the bar, I guess first I worked for a family law firm, did some trial work there, and then I worked for a bankruptcy firm, and did some bankruptcy law there, probably about, I don't know, maybe a year or two. And then I moved to the AG's office, and I was in post-conviction appeals there, but on the other side, working for the state of Georgia. And then I had to stop working for a little bit due to some family matters. And then when I started working again, is when I started doing contract cases in the appellate division with the Georgia Public Defender Council. So that was probably, I want to say 2016 or maybe 2016, 2017, I think, when I started doing appellate cases with them. And I probably did that for about, 5 years before I was hired on full time. So In the criminal realm, I've only done appeals. I've never done any trials or anything like that.
So it's fair to say that you're a specialist of appellate cases.
I mean, I don't know if I'm, I don't know if I want to call anybody in the appeals section a specialist, but yeah, I guess that's my main focus is appeals.
All right. Do you recall any of the specifics of my case?
Yes.
Could you give a brief overview of what you do recall about my case?
Yeah.
All right, guys, buckle up. We're going to hear some facts about his case.
So your case, it was a complicated one. I do remember that. I think the main problem with your case was that you were accused of murdering Miss Blackwell. And the state is alleging that you did it through cocaine intoxication. But they didn't really have any evidence at trial that you gave her the cocaine, that you sold cocaine, that you did cocaine yourself. Any evidence of trial regarding the cocaine was pretty almost non-existent. The only evidence they had of cocaine at trial was that when Miss Blackwell, when they did, I guess, the blood test, they found, cocaine in her system. And they tied it onto you, I guess, because, I don't know, I guess you were the last person to see her or something like that. That was one thing that really bothered me about the case. The other thing, I think, was the rape conviction with another young lady that they wouldn't sever from this case with Miss Blackwell because you were accused of rape and murder with her. And then there was another rape case with, I can't remember the name of the alleged victim there. But so you had those three main charges in your case. They wouldn't sever that one rape with Miss Blackwell. And also the second rape that I was talking about, I think it was, do you remember the name of, I can't remember the name, but there was some constitutional speedy issues with that case because it sat, I don't know how long until you went to trial on that. I mean, it was a long time, and that was argued by your trial attorney, and I raised it in the motion for new trial level, and I raised it on appeal, and it didn't go anywhere. But those were probably the serious issues that I saw. In regards to, is there something else you want to know about your case? Like, can you just be more specific, and I'll try to tell you exactly, what you want to know.
Just wanted to know what your general overview was. So you would agree that the defendants or a defense attorney has a duty to do a complete investigation of the state's discovery prior to trial?
Yes, I agree with that. Yes.
That would include a thorough examination of the indictment, right?
Yes, I would agree with that.
Okay, you raised 4 issues on direct appeal in the Georgia Supreme Court, and of those 4 issues, the one I want to discuss here today is exactly the murder's level of sufficiency and the language that's in the indictment,
right?
Where it specifically says that I, with forethought, caused the death of Monica Blackwell, a human being, by cocaine intoxication in a manner unknown to the grand jury, and dumping her body on the side of the road without medical assistance.
Right.
Accurate?
Yeah,
okay.
Sounds right.
All right. Now, correct me if I'm wrong, but the gist of your argument and the problem with the language in that indictment is that it precludes me from being able to prepare and present a defense.
I guess you're talking about a general demurrer. Yeah, I mean, I know that was argued pre-trial, and the judge denied it. And so, with regards to general demurrers on appeal, basically, it's an abuse of discretion standard when the appellate court looks at the affirmance or denial of a general demurrer. I guess I didn't raise that because I didn't think what the judge did. It came because the abuse of discretion standard is so high. The appellate courts give a lot of deference to trial judges and the, evidentiary rulings that they make pre-trial and during trial. And a general demurrer is very, I know, we would love it to be where an indictment is pure in form and, says everything that it's supposed to say. But and honestly, I don't think the courts see it that way. I think if it just gives the defendant, notice of the charges he's going to be up against, and that would be murder, then I think it can pass muster. At least that's my understanding. In the short experience that I've dealt with, try to raise general demurrers or try to argue that on appeal. And I think that's what I saw in your case was that, I could be wrong, but I think that's probably why I didn't raise that.
Okay. Mr. Chappell, and you do remember at the conclusion of the state's case that my trial counsel did move for a directed verdict or acquittal.
Yes.
Because the prosecution clearly failed to prove that I somehow put cocaine in Ms. Blackwell's system.
I do recall the motion for directed verdict, yes.
Okay. Now, out of the issue that you did raise in the Supreme Court came to fruition several other claims, which were discussed both in the majority and the dissenting opinions, namely the fatal variance.
Yes.
Do you recall that?
Yeah, I remember reading that in the opinion, yes.
Are you familiar with the concept of a fatal variance, Mr. Chappell?
I am now.
Well, could you...
At the time when I did your appeal, that nuance of that issue I was not aware of. If I had known about a fatal variance argument, I definitely would have raised it.
Okay. Well, could you, for the record, give your interpretation of what a fatal variance is now that
Yeah, it's when the indictment alleges something and then the evidence at trial basically proves something else. So there's a variance between what the indictment says and the evidence that came out at trial. So it's a little bit different than insufficiency of evidence standard. And from now, after reading, the opinion, the courts look at it differently. So it's something that has to be raised specifically and something that has to be argued specifically for the courts to take a look at a fatal variance.
So you did note in the opinion where it notes that that your argument in brief does note the difference between the allegation and proof.
Yes.
And that basically they state that you failed to properly frame the argument as a fatal variance claim.
Yeah, I saw that. Yeah.
So because trial counsel didn't argue or raise an obvious fatal variance during his motion for a directed verdict, that can necessarily be construed as ineffective assistance of trial counsel, couldn't it?
Yes.
Okay. In addition, recall in your review that the alleged victim, and this is for a lack of a better term, was a cocaine addict or a junkie?
I'm trying to think about the trial. I don't recall. I'm not saying that you're wrong. I don't specifically recall testimony that she was a cocaine addict. Maybe she was a former cocaine addict, but it sounds vaguely familiar what you're saying. So I'm not going to say you're wrong.
So in your professional opinion, hypothetically, had you been defense counsel, how exactly would you defend against such a charge, the one I've laid out here?
Okay, can you repeat the question?
Okay, hypothetically, if you were a defense attorney, how would you defend against the charge the way it's written in that indictment?
Against what specific charge are you talking about? The murder charge?
Yes, murder charges.
In regards to cocaine intoxication?
exactly?
I don't know, Mr. McCollum, that's a good question. Like I said, I don't do trials, so I don't have experience in preparing a case for a trial. I've been trying to get more trained on that just so I can answer a question like this, but seriously, I don't know.
Fair enough.
Yeah.
So,
Sorry.
but your argument on appeal,
Yeah.
pursuant to Jackson v. Virginia, was simply, that the evidence was insufficient from a legal standpoint for a jury to be authorized to find me guilty of the murder counts.
Yes, I thought it was legally insufficient because the state hadn't proved. I don't think they proved the essential element that the causal connection between the cocaine intoxication and you, and which I thought they had to prove because you have to prove causation for a murder charge.
Yes. Now, wouldn't you agree that Jackson v. Virginia is overly broad, leaving a jury as well as a reviewing court a lot of leeway?
Yes, it is very broad. Any rational trial of fact can find, the standard. It's very broad, but I understand why it's broad. But yes, I agree with you. It is broad.
So, in other words, it's fair to say that Jackson v. Virginia can be interpreted to read that unless a verdict is clearly erroneous, that the jury's decision won't be disturbed.
I don't necessarily agree with that. I don't know if it's a clearly erroneous standard. I don't know about that. I don't think Jackson says that unless it's clearly erroneous. I don't think the opinion says that. I think the opinion is broad in that, our judicial system is based upon the jury and what the jury finds at trial. They're the ones that assess the credibility of the witnesses. They're the ones that listen to the evidence. And I think, they're the cornerstone of this judicial system. So they have to be given deference to how they view a case.
Okay. But it is clearly a difficult standard to overcome, right?
Yes, I agree with that. It is clearly a difficult standard to overcome with regards to insufficiency of evidence.
So, in the end of all of this, a fatal variance claim would have been the legal correct path to be taken on this appeal.
I think it would have been in conjunction with the insufficiency of evidence. I think so. I think I should have argued both. I should have argued insufficiency of evidence because I thought the evidence was insufficient, and I should have made the fatal variance error probably as a separate enumeration of error. I think to give the court, another way, to give the court another position on how to look at this evidence and how to look at the indictment and what was proved at trial.
Okay. Now, during your review of the opinion on this case, did you take any notice of the court's discussion on the Musacchio case? I don't know if I'm pronouncing that right. Okay.
I did. Yeah.
Okay. So, I'm sure you read the Musacchio case somewhere along the line.
Well, I haven't gone back and read that one very well. I just kind of read what the court said about expanding Jackson, Virginia. I didn't read that case before handling your appeal. Probably if I had read that case before handling your appeal or while I was writing your appeal, I might have included that argument that the defense suggests, or dissent suggests, but I hadn't, so I didn't even think about it.
Okay. Have you read it since then?
No, I have not reviewed it. No.
Okay. So you're not aware of okay. And the opinion in this case The Supreme Court notes that in Musasio, they left a question open in the footnotes.
Yes, I read that. Yep.
And do you remember in the opinion in this case where the court said that they will not decide a difficult question of federal constitutional law as you had not raised or addressed it, such a claim?
I think I recall that, yes.
Okay. And the element in the murder charge, clearly questionable, is causation in this case, correct?
Yes, I agree with that.
And this once again brings me full circle back to the fatal variance. So is it, now not having being familiar with fatal variance, you couldn't have possibly did any research about it. Is that correct?
Before or right now?
No, before.
Yeah, before. No, yeah, I didn't do any research about it because it was just something that, I mean, I might have read about it before, but it just didn't pop in my head when I was, writing your appeal. When I was researching your appeal, I don't recall ever researching fatal variance. Not to say that I haven't read about it before, but I didn't specifically do it for your case.
Okay, and specifically in the opinion, did you know where the court says in lieu the way that the issue was raised, that they've been discussing, that you should have raised it as a trial court error and denied that it as a trial court error for denying the motion for a directed verdict of acquittal?
Okay, repeat that question. I'm sorry.
Okay, in the opinion in this case,
Yeah.
The court noted that in lieu of the way that you raised the issue that they were discussing,
And in lieu of the way who raised the issue, I did?
in lieu of the way you raised the issue
Okay.
in the brief, even though they were having a discussion about it, that you should have raised it as a trial court error for denying the motion for a directed verdict.
I did read that, yes.
So basically, the court is informing us or just gave us a blueprint as to how the issue should have been raised on direct. Would you agree with that?
The court, yeah. I mean, the opinion was difficult to read. I realized that I did miss some things, so yeah, it was difficult to read.
And are you familiar with the effect of cumulative errors?
Yeah, State v. Lane. Yep, sure.
Okay, and so it takes a minimum of 2 errors combined or 2 by one side or the other to be considered cumulative. Is that correct?
Well, I think State v. Lane, it's cumulative in the fact that it's trial errors along with ineffective assistance of counsel.
Yes.
So it's not necessarily that it's just 2 trial errors you can raise State v. Lane. I think it's if you have a couple of trial errors and then you have ineffective assistance of counsel. But then again, for State v. Lane to apply, the ineffective assistance of counsel has to be ineffective. So
13 months. Oh my gosh, another one. Yes, let's go. Donald and Micah, thank you so much. 13 months. Thank you. I appreciate that.
the IAC claim isn't good, or if the IAC claim isn't a good one, then it's not going to help your State v. Lane claim either.
Okay, but in this instance, would you agree that pursuant to the Supreme Court's opinion, trial counsel was ineffective for failing to present a fatal variance in his motion for a directed verdict of acquittal, and the trial court erred in failing to grant the motion for directed verdict despite the fatal variance omission by counsel?
I mean, I don't know, Mr. McCollum. I mean, it's hard to say yes to that. Okay.
This is what the Supreme Court wrote in their opinion.
Yeah. I mean, I don't necessarily agree with that. That's what they wrote. I mean, I have to go back and look at it again. I reviewed it a little bit before the hearing today, but I need to read it again. But, okay, I'm sorry. Repeat your question.
Okay. Let's say in this instance, this is pursuant to the Supreme Court opinion, trial counsel was ineffective for failing to present a fatal variance in his motion for directed verdict of acquittal, and the trial court erred in not granting the motion for directed verdict despite the omission of the fatal variance by trial counsel.
I don't recall them saying that trial counsel was ineffective for doing that. But do you know where that is? I don't recall that they said that trial counsel was ineffective.
Well, I'd have to go back and get the opinion, read through it again.
Yeah.
But, well, I'm asking you for your opinion. I mean, because of what's written in the opinion.
I think you can make an argument. Now, for me to say that trial counsel was ineffective, I mean, I think ineffective assistance counsel is also very difficult to, it's a very difficult standard to meet. So if he had raised a fatal variance at his motion for directed verdict, had the trial court granted it, I don't know. I mean, that's what you're saying ineffective is. You're saying that he should have raised it, and had he raised it, the trial court would have granted the motion for directed verdict. That's what would be ineffective. So you have to prove both prongs. Now, to say both of that would happen, I don't know. I'd say that he probably should have raised it. As to whether it would have been granted, I don't know.
Okay. Now, would you agree that as a matter of right, defendants are entitled to effective assistance of counsel at first appeal?
Yes, absolutely.
And according to the court's decision, this issue we've been discussing, you were ineffective on this appeal.
I object, Your Honor. That calls for a conclusion that's within the province of the court to make, not for Mr. Chappell or any other witness to testify to.
Well, Mr. McCullum, Mr. Daniels has objected and said, and to the form of the question that you're asking the witness for an opinion about the Supreme Court. And I understand what you're trying to get at, Mr. McCullum, but I can read the decisions myself. We need to tighten this up a little bit and keep your questions focused to what Mr. Chappell did or didn't do, and then you can make a legal argument to me later. But I'm going to sustain the objection. We got to make sure that you keep your questions limited to what Mr. Chappell did. I'm not really too concerned about his opinion about a Supreme Court opinion. I can read it myself. So let's move along, Mr. McCullum.
Yes, sir. But so we are back to this issue of the fatal variance that at the time, I mean, you didn't write this up as a fatal variance because you weren't well versed on it.
Correct.
Is that correct?
I did not write it up as a fatal variance. Yes.
Okay. Well, thank you, Mr. Chappell. Your Honor, that's all I have for Mr. Chappell.
All right, Mr. Daniels, cross-examination.
Yes, Your Honor. Mr. Chappell, where'd you go to law school?
I went to law school at Georgia State, or Florida Coastal, and then finished up at Georgia State.
And when did you become a member of the Georgia Bar?
2012.
And have you been a member in good standing since you joined the bar?
Yes.
I understand you had sort of a varied practice, but at the times that you were representing Mr. McCullum, were you regularly attending CLEs and seminars related to criminal law?
Yeah, Mr. McCullum's case, was one that when I was a contract attorney, we would bring difficult cases to the Georgia Public Defender Council to discuss in case discussions. And his was one of the cases that I did that with. And do you generally recall that Mr. McCullum was convicted of one count of felony murder predicated on rape, one count of felony murder predicated on aggravated assault with intent to rape, and one count of malice murder? Yes, I do recall that.
And I think there were some other convictions, but just related to murder, those were the 3 murder convictions.
Yes.
And they were all for the murder of Blackwell, Monica Blackwell, correct?
Correct.
From a sentencing perspective, is there a difference between malice murder and felony murder?
No, there's not.
So when the dissent in the Supreme Court of Georgia noted that perhaps you didn't raise something as a fatal variance, but noted that in previous opinions, the Supreme Court had considered insufficiency of the evidence as a fatal variance argument, sort of intermixed. The dissent only notes that it would have reversed the conviction as to count 1, the malice murder, right?
That's correct. Yep.
And Mr. McCollum's convictions for felony murder were essentially merged into that conviction, right?
No, I mean, I don't agree with that. They're not merged. Felony murder, when you're convicted of malice murder, it's vacated by an operation of law. So I don't necessarily, I guess you can say it's merged for sentencing purposes, but they actually vacate the conviction.
So the practical effect of his conviction for malice murder being vacated would be what?
Why, you mean the felony murder? I'm sorry.
No, but
so with the conviction, I'm sorry, go ahead. I'm sorry, Mr. Daniel. Let me interrupt you.
Sure. Wasn't the malice murder the one that would have been subject to the fatal variance?
Yes.
And if in fact it was a fatal variance subject to being vacated,
yes,
what would have been the practical effect once it was remanded to the trial court?
I don't know. That's a good question. Because the felony murder was vacated upon conviction of the malice murder, would he be retried then because the felony murder was vacated, or would the felony murder come back into play? Like, I don't understand. I don't know the question of that or the answer to that.
Sure. And then I believe you said that the terminology used was the felony murders would have been vacated by operational law by virtue of the conviction for the malice murder.
That's my understanding, yes, because I've had many sentencing errors where they merge it and then the court will go back and say, this isn't actually a merger. It should be vacated by operation of law. So, and I think in my opinion, or in my brief, I also raised the insufficiency of evidence with regard to the felony murder, and the court addressed that and said, those questions are moot because, the felony murder was vacated.
Do you recall whether or not the dissent notes that, in its opinion, what it would have done, the 3 justices who were dissenting, is to reverse the conviction for malice murder, vacate the trial court's judgment with respects to counts 2, 3, and 4, and then remand the case for resentencing on those 3 counts?
Yes, I think I recall that. Now that you mention it, sorry, yep.
So in practical effect, Mr. McCollum, if he had prevailed on the fatal variance argument, would be convicted of at least 1 count of felony murder and received, most likely from the trial court, the same exact sentence that he's currently serving under.
Yes, and if I'm not mistaken, yes, that's correct.
That's all the questions I have, Judge.
Mr. McCollum, do you have any redirect questions for Mr. Chappell?
Yes, I do. Just one question.
All right.
The language in the indictment for the felony murders and the malice murder for the causation is the exact same, isn't it? Is it not?
No, I don't think so.
If you're new, make sure you come to Discord. We're all in there. We all talk 24/7. Come to Discord. It's free.
Well, Mr. Chappell, what was Monica Blackwell's cause of death?
Cocaine intoxication.
And that is what it says in the indictment for each of the murder charges, isn't it?
I think there was also felony murder with something else other than the cocaine. Wasn't it like intent to rape or something like that? I can't remember off the top of my head.
I got an issue with cocaine intoxication as a murder. I mean, because okay, I might be stupid, but cocaine you stick right up your nose, right? Is there another way that she could have, like, could he have injected it into her? Because if she did that, I I mean, how can he be charged with killing her when she clearly did that to herself? Maybe, I mean, even if she, unless, unless he, like, poisoned the cocaine with something, doesn't sound like it. He's not being charged with poisoning someone. He's being charged with, her having too much cocaine. But you can't really make someone. Can you put enough on her gums to kill her? I wish they would say how she ingested the cocaine. It doesn't matter because all he's fighting about is the cocaine. He already has all those other horrible charges that another murder and the other charges that he okay, yeah, that I could get. That you could take me there, but yeah, but she did it. She snorted it right up her nose.
Well, no, we're talking about the actual cause of death.
Well, see, with felony murder, I mean, that's the thing. I mean, I don't necessarily know if you have to prove causation. You just have to prove that the felony that you committed, a death resulted from that felony. So I don't know, Mr. McCollum. I think it's a little bit different than proving like causation in regards to felony.
Okay, that makes sense. The felony you committed resulted in her death. So he did provide her with cocaine, but he's saying he didn't provide her with any cocaine. And that cocaine did, in fact, kill her. So that was a felony to sell her drugs or give her drugs.
With regards to malice murder.
Okay, we're talking proximate cause, but all these charges were charged in a single indictment and tried together. Is that correct?
Yes.
Okay. Thank you, Mr. Chappell. I have nothing further from Mr. Chappell.
May this witness be excused, Mr. Daniels?
Yes, Your Honor.
All right, Mr. Chappell, thank you for your time, sir. You are excused. You may terminate the connection and go about your business. Thank you, sir.
Thank you, Judge.
All right, Mr. McCollum, do you have any other witnesses or anything else to present?
I don't know injecting. I'm not familiar with that. But if you smoke it, isn't that crack? Then wouldn't they be calling it crack? Because that makes sense. I mean, but again, he would have to force her to inhale it. She probably inhaled it if she smoked it. She probably inhaled it on her own volition. Double dip chocolate, jeez.
At this time?
Not at this time, Your Honor.
Mr. Daniels?
Your Honor, I would tender Respondent's Exhibit A, which is a complete copy of the filings of the Georgia Supreme Court and Mr. McCollum's direct appeal.
And Mr. McCollum, as I indicated at the very beginning, Mr. Daniels does in fact have the electronic copies of all of your proceedings below. Do you have any objection to those materials being admitted into this record?
No, Your Honor, I do not.
Very well, so admitted. Anything else, Mr. Daniels?
No, Your Honor.
All right, Mr. McCollum, as I stated at the very beginning, what's going to happen next is the court reporter is going to prepare a transcript of today's proceedings, and when it gets filed in, you will be provided with a hard copy to be delivered to you at Telfair State Prison. Once you receive it, you will have 30 days to file any sort of written closing argument or brief that you feel is appropriate, and Mr. Daniels, of course, will have the same opportunity, and then after all of that is concluded, the court will then make a decision. Do you have any questions about that, Mr. McCollum?
No, sir, I understand the process.
Very well. The evidentiary portion of this proceeding is now closed, and you'll get your transcript in due course, Mr. McCollum. I'm not going to say it's going to be within a week or two, but it will be very shortly. But that will
Okay.
conclude the proceedings for today. Mr. McCollum, you are excused. Thank you very much, sir.
Okay,
Thank you,
guys,
Your Honor.
if you happen to live in Australia, you're going to immensely struggle with this next one. I very much struggle with this next one. This Georgia accent is so thick that I'm really not sure I know what he's saying most all of the time. It's just such a thick accent. But we got another habeas. We got another habeas that starts around. Yeah, that's him. That's him. That's him. And now remember, guys, he's in this magic box on the wall. He's in this little seat right here. And his accent, oh my gosh, you're gonna fall in love. I don't know what he did. I didn't listen to it. Basically what I did was spot heard it to make sure that it was a full hearing so we get to see the full hearing, but I didn't hear anything other than his accent. And let me just tell you, I didn't understand what he was saying when I was watching it. But I was also cooking. I was also, getting the cat stuff while I was getting this ready. So wasn't fully focused. It's hard to get me to fully focus. Even right now, I'm doing 17 other things right over here. I'm not fully focused. I'm partially focused. This is why I'm single. Because those men folk require 100% focus, and I just don't have 100% to give. This is another habeas, so that just means he's in jail. He lost a trial. He's in jail, and he is saying that the trial was flawed. And his most of the habeases we see are ineffective counsel. That's their grounds, ineffective counsel. So not the last one. The last one was not ineffective counsel. But get ready, here he's sitting there. He's in his little magic box. We're just waiting for the judge. And Anthony's in the background. There's the judge. I can't. I wish, guys, we got to figure out this judge's name because we watch him all the time. And maybe you guys already know his name, but I don't.
In this case, is that correct? Durden.
I put it to the beginning in case he said his name.
All right, we got everybody. You ready to start back, Mr. Daniels?
Yes, sir.
All right, are you Mr. Durden?
Yes, Your Honor.
All right, good. Give me just a minute, Mr. Durden. I'll bring.
Yes, sir.
And Mr. Mills is in this case, is that correct? Mr. Daniels?
Yes, Your Honor.
All right, let me make a note of that.
Mims is the appellate counsel. William, but it's not, there's no B in Mims. It's,
William Mills.
I'll give him spell it.
M-I-M-S.
It's up there. I can't read it, but it's up there.
All right, I'm gonna bring Mr. Mills in.
Tell him your name, Judge, please. Just an update, if you guys are following along with me, there's these RICO cases in Georgia. A whole group of them. I think like 15 or so people in these RICO cases in Georgia. And they brought them in again last week to give them attorneys. They still don't know any of their charges. These people have been sitting in jail now for probably 2 years. Maybe that's an exaggeration. Maybe it's a year and a half. It is at least a year and a half to 2 years. and none of them have been indicted, I don't think. If any of them are indicted, it's just one or two. Anyone who has been indicted still they don't know their charges. They have not charged them with a crime at all yet. It's been years, and they just sit there and they don't get any bond, and they keep coming in front of this judge particular to get a bond. No bond for none of them. No, nope, nope. And they just sit and we just wait. And we've been watching them because it's crazy. But just so you know, they all now have attorneys. And because that's what they did last week. They made sure everybody had attorneys. But it doesn't mean anything because the attorneys, they have nothing. They have no discovery. They have no charges. They have an arresting document, and that is the only thing they know. And it doesn't list the crimes. So they have no idea what the crimes the people that they are defending are facing. It's just unbelievably bad. I don't know what these people did. I know it was Rico. I know that they tried to bring drugs and weapons and cell phones and all kinds of stuff into the prisons. They got caught feeding the prisons with a whole bunch of contraband. But other than that, that's just a guess because that's just something they said in passing in all these hearings that I've been watching. But it's bad. I have to say it's unconstitutional. It is not constitutional to do this to people. You can't just lock people up for years without charging them with a crime. And it's not just these 17 RICO people. This is common in Georgia that you could just get arrested for years without being indicted or charged with a crime. It happens all of the time. It's not okay. That's a completely separate but connected issue. The prisons and the jails are so bad in Georgia. Their living conditions are horrid. And you're stuck there for years with no way out. No way to get out if you're innocent or guilty or somewhere in between. It's not okay. And sorry, you can't just blame Fonnie Willis. You can blame Fonnie Willis. She's the head honcho. But she walked into this. This is exactly how it was when she walked in. And it's too much for her. She can't just snap her fingers and fix everything. There's nothing she can do to fix everything. Um so yeah, you can blame Fonnie Willis because she's the boss right now, but she didn't create this mess, and it's really, really, really bad. It will take, I don't even know what it'll take to fix Georgia right now.
Apparently it's Mills.
Come on, Judge, let's go.
All right, let's get on the record. The court calls at this time position number 3 on my calendar today, case number 24CH036. Jonathan Colby Durden. Is that you, sir?
Yes, Your Honor.
Mr. Durden appears to us today from Telfair State Prison via our video platform Zoom. Mr. Durden, I have some just general announcements to make here. I am presiding today from the Telfair County Courthouse. I know your screen is very small, but you should have our courtroom camera where you can see Mr. Daniels and Ms. Browning. I also have the clerk of court, Ms. Royal, here with me, and the court reporter. I will note for the record that Mr. Mills has logged in and he is standing by when needed. And this matter is on my calendar for an evidentiary hearing. Mr. Durden, this is the opportunity for you to present whatever evidence, testimony, documents, exhibits, or other matters that you contend are in support of your application for writ of habeas corpus. I'll go ahead and state now that usually Mr. Daniels will present to the court a complete copy of your trial and all of your appellate materials that will be submitted into the record as well. And after we get through today, you will be provided with the hard copy transcript of all of it and then delivered to you out at Fairfax State Prison, where you'll have a certain amount of time to review it. You understand everything so far, Mr. Durden?
You said I'll be delivered what?
You'll be delivered, hand-delivered, a hard paper copy of the transcript of today's proceedings, as well as the all of the materials from your original conviction and appeal. Do you understand all that, Mr. Durden?
Oh, yes, Your Honor.
All right, very good. As I stated at the beginning, this is the evidentiary hearing. So, Mr. Durden, are you ready to proceed with your case?
No, Your Honor. If it pleases the honorable court, I'd like to move for a short continuance due to not being permitted proper and lawful access to Fairfax State Prison Law Library. If the state has no objection to this motion, that is. All I'm seeking is 30 to 90 days to be prepared, Your Honor. I have in my possession a copy of the grievance I filed against Respondent Warden Andrew McFarland. I'd like to tender this for both Respondent counsel and the court for review, if you will allow me, sir.
You have a what in front of you?
I have a copy of the grievance I filed against Warden Andrew McFarland and the receipt of the grievance, a handwritten copy that I filed.
So a grievance.
So I've not been able to receive no law library time here. And they just recently moved to where we get it 30 days before the court date, but I've never got to go to the law library one time since I got my last continuance, Your Honor, and I've had no opportunity to work on this. I've been at this prison for over a year, and I've got 2 hours in a year, and that's the bare minimum because the COVID pandemic's got it locked down. And in this camp, there's so many murders, and it's so understaffed. They just physically can't get us back and forth. And I've done everything in my power by.
Isn't his accent so good? This is the best accent we've had in a while. I love it. I love it. I'm keeping up. He can't get back and forth to the law to the law library because there's not enough prison guards to take them all back and forth in the prisons. Like I was saying, the prisons are terrible. I have to thank. It came up on a different screen and I wasn't watching it, guys. But okay. 42 minutes ago, Kelly sent me a bit in Twitch. Thank you so much. 41 minutes ago, Monica did. Thank you so much. 31 minutes ago, Kelly did. 35 minutes ago, Monica did. 34 minutes ago, Kelly did. Monica sent me 6 bits to make the little snowman with the carrot dissing a. Oh, that's so cute. Kelly did it 27 minutes ago. Monica cheered 1 bit 23 minutes ago. 5 minutes Kelly did I think 3 bits. Monica cheered a bit 3 minutes ago. Kelly 3 minutes ago, and Kelly 1 minute, 2 bits, 1 minute ago, and 3 minutes ago. Thank you so much. I'll keep an eye on it. I'm so sorry. All right, here we go. Thank you.
Filing grievances. I've talked to the man in the law library, and he assured me I would be able to get some law library time before this court date, and I've never got 1 minute since the last continuance I got.
When was
So
that?
I've had 2 hours. I don't know his name, but
Hold on, wait. We can't talk at the same time. Go ahead, Mr. Durden. When were we last here?
April the 22nd, I believe.
Oh, I see that now. Okay. Is this evidentiary hearing or a motion to dismiss, Mr. Daniel?
Yeah, this is evidentiary.
That's what I thought. Okay. Well, let's see. Your original application for writ of habeas corpus was first filed in Chattooga County on July 23rd, 2020, and transferred here in 2024. You agree with that, Mr. Durden?
Yes, yeah, I originally filed it, yeah, that was when I originally filed it. And it was transferred after being transferred from Hancock State Prison last year.
I got you. All right, Mr. Daniels, what is your position on Mr. Durden's new request for a continuance?
Your Honor, this is the same story we heard back in April, except the one minor difference is in April, he also suggested that he was trying to retain an attorney. At that time, I also objected to a continuance, and this court, as I recall, overruled my objection to continuance and said words to the effect that you were going to give Mr. Durden one last opportunity to get ready or to retain counsel. And here we are in August, almost 4 months later, not quite 4 months, and we are getting the same argument that he's not ready. This case has been pending now for over 5 years. I don't know what more time Mr. Durden can need to prepare that he has not been afforded in 5 years' time. We're ready to go forward. We have as appellate counsel here, and the court has heard nothing other than he wishes he had more law library time to prepare to suggest that there is any basis of anything in this case complex enough to warrant it being continued again for now that it's been 5 years since it was filed.
All right, Mr. Durden, I'm going to get a couple of things on the record here. As I stated earlier, I don't have any idea why you didn't get a hearing in Chattooga County. But the fact of the matter is your case had been pending for at least 4 years before it was transferred here to Telfair. And since it's been transferred to Telfair, you have apparently already been granted one continuance. Mr. Daniels, did you subpoena Mr. Mills?
Your Honor, Mr. Mills appeared without subpoena, but I did ask him to appear.
All right. And to make a long story short, Mr. Durden, I don't want you to think that I'm being unnecessarily harsh, but it's time for this case to move. Mr. Daniels is ready. I'm ready. Mr. Mills is ready and has voluntarily appeared, and we have imposed upon him enough. So we are going to proceed today. Mr. Durden, your request for a second continuance is denied for the reasons stated. Are you going to testify yourself, Mr. Durden?
I've had a lot of issues. I've been locked down over these last 4 years where I haven't been permitted no access other than the card that comes in, which has been deemed ineffective. And my trial transfer was seized at Hays State Prison for 2 years. And I had no opportunity to work on them at all. And I filed agreements, and y'all can track through my agreements record. I've either been locked down with nothing but the card, which has been deemed ineffective, or my trial transcripts have been seized for over a year at one time. And I have not physically had time to really work on this that's adequate and effective, to actually build a case myself. My family was trying, they had told me they were trying to get me an attorney, but that never come through. But I've been working my best for doing it from memory, but as far as not having trial transcripts or access to the court and nothing but a delivery card, which I got many cases here where it's all been deemed inadequate, and I've just physically not had enough time to prepare defense as adequate, meaningful, and effective, sir.
Well, I understand, Mr. Durden, and you'll just have to deal with that somewhere the way your request for continuance is denied. So, Mr. Durden, I'm going to give you the opportunity to proceed and present whatever you want to present at this time, as long as it is relevant and germane to your case. But it's time to move, Mr. Durden. So what do you have to present to the court today?
Let me find,
Well, while you're looking, let me go ahead and make one further announcement to you. I have your whole file here in front of me. I see what you originally filed in Chattooga County that sets out your grounds that you contend or the issues before the court today. I have reviewed that, And I understand what you have put in your petition, so I don't need you to read that to me or read anything else to me. As I stated at the beginning, this is an evidentiary hearing. I'm here today to collect testimony, evidence, or exhibits that you contend are in support of your application for writ of habeas corpus. So it's time to proceed, Mr. Durden. Do you have anything to present to the court today?
What do you mean, sir?
Well, Mr. Durden, I can't give you legal advice, Mr. Durden. And I mean, I understand your position and I'm not fussing at you. I'm just stating I am not allowed to help you with this. It's your burden and you have to do it on your own. So if you have some evidence, exhibits, or documents to present today, now's the time.
I was served, my respondent said that I was facing charges from a double homicide that happened in Columbia County in 2003 that was served by the Attorney General to me, and that has confused me so much. I was given paperwork about it saying I was charged with I've never even been to Columbia County.
Well,
if you look at the paperwork, it should.
Mr. Durden, that issue is not before me. Your application for writ of habeas corpus challenges your original conviction from Whitfield County, and you state in your petition that the date of the conviction was November 25th, 2013, so your case is bumping on, goodness, 12 years old now, and I don't know anything about Columbia or other county, and that's not relevant to your challenge of your Whitfield County conviction for murder and possession of a knife during the commission of a felony. So this is the last time I'm going to ask you, Mr. Durden, do you have any testimony, evidence, or exhibits to present in support of your application for writ of habeas corpus challenging your Whitfield County conviction?
Come on, buddy, please.
I'm trying to understand what you said, sir. I'm not real versed with it.
It's the judge's accent, I bet. He doesn't understand what he's saying.
No, and I'm trying to, I don't, is there any way you could fax a copy of what I sent y'all? Cause I had that seized at Hays State Prison. I filed agreements, never returned to me. So I only have a copy of the original that I mailed to y'all. Can y'all please fax that so I can even see my original argument? Cause that's been 5 years ago and I've tried everything from filing grievances. I did everything in my power to fix this problem, but between the officer seizing my trial transcripts and retaliation to me,
all right,
catching charge.
Oh God, I'm so pissed off, guys. Guys, this is not constitutional. This is not fair for these guys sitting in jail. All right, I don't care what his crimes are. I don't care if he is a mass murderer. This is the United States of America. In the United States of America, you have rights. And even if you give him all the stuff that he needs legally to do this, you know, he's still going to spend the rest of his life in jail for murder if he murdered someone. This is not okay and not constitutional. He has no idea what's going on because he filed this 5 years ago. 5 years ago, he sent that piece of paper out, and now they're asking him about that piece of paper because they took it from him. They took a piece of paper from him. Yeah.
Take a breath. Take a breath. I
take
want
a
you. I
breath.
want you to understand
You're
one
the
thing.
problem.
I'm not going to kneecap you, as I said at the very beginning. We're going to proceed today. Mr. Daniels is going to admit into evidence your entire Whitfield County record, your transcripts, exhibits, everything, including.
That doesn't give it to him, though. How is he supposed to get that? Should he just hop on his computer and download it from his cell, from a computer he's not allowed to touch?
Any and all appellate materials, plus the transcript from today. You will get a hard copy of all of that once the court reporter gets it all pulled together. And then you can file a written closing exhibit or argument or brief if you choose to do so, but that will be later, not to.
Okay, that's better. That's better. It's better actually than him trying to do it here live to the judge. Because he can sit, he can think, and he can put it all together, his responses. Okay. My blood pressure went way down now. Okay.
Day. You understand that, Mr. Durden?
Okay, yes, sir. Okay, yeah, okay, yes, sir. I understand what you're saying.
All right, very good. So,
I have additional time to respond to the state's defense, right?
I'm going to give you
If I
time. Yes,
choose
sir. I'll
to.
come back to that. Hold on. Hold on. I'll come back to it. All right, Mr. Daniels, what do you have today?
We'll call Mr. Mills.
All right. You may swear him in and proceed, Mr. Daniels.
If you'll raise your right hand. You swear or affirm the testimony and evidence you're about to give the court is the truth, the whole truth, and nothing but the truth to help you?
I do.
And would you state and spell your name for the record, please?
My name's William Burton Mills Jr. It's William Burtonmills Jr.
And how are you employed?
I'm currently working with the Public Defender's Office here in the Lookout Mountain Circuit.
Where'd you go to law school?
I went to Barry in Orlando, Florida.
And when did you become a member of the Georgia Bar?
I guess that was 2009.
And have you been a member in good standing since you joined the bar?
I have.
Can you walk me through generally what the nature of your practice has been since you became a member of the bar?
Well, I worked for the Public Defender's Office for almost 2 years, and then I worked with a private attorney that's local for a year or so, and then I opened my own practice probably around 2012. I was in private practice all the way up until about maybe 10 months ago when I shut down my practice and I came back to work here for the Public Defender's Office. That practice was a solo practice that did almost everything except for tax law and bankruptcy and personal injury. So I continued to do criminal defense. I think I had my own business, William B. Mills PC, at the time I did the appeal for Mr. Durden, but I'm not sure.
Were you retained or appointed to represent him?
I believe I was appointed because one of the things that I continued to do was take conflict cases and appointed appellate cases. And I did that up until probably 2020.
At the time that you would have represented Mr. Durden, did you regularly attend CLEs and seminars related to criminal law?
I did.
And roughly how many appeals do you think you had handled or have handled now?
I couldn't give you an exact account. I mean, I probably have 25 or 30 appeals that I've done. As an attorney, I did most of those up until 2020. I had done several prior to taking Mr. Durden's appeal, more than, probably around 10 or so.
Could you walk me through what your process normally was once you either were retained or appointed on a post-conviction matter in terms of steps that you took as an attorney?
Yeah, I would, I'd file substitute counsel. We'd have the motion for new trial was typically already filed by the trial attorney. There would be, then I would seek out the transcripts, obtain those transcripts, however necessary, review the transcripts, file an amended motion for new trial based on the issues that I could discern from the transcripts, come up with the argument, write the brief, and then submit the brief.
And I know that it's been some time since you handled Mr. Durden's case, I think right at 11 or 12 years. But is that generally what you did in his case, the best you can recall?
Yes.
Did you consider raising any ineffective assistance to counsel claims on behalf of Mr. Durden?
Some of the issues has been quite a while, but typically my procedure would be to talk to my client about that. And if they wanted to do it, I would generally assert it. If it wasn't asserted in the brief or as one of my enumeration of errors, and I would assume that there either wasn't any kind of issue or Mr. Durden didn't request that I do that, but I can't remember specifically for his case.
Do you recall ever discovering that there was information or evidence favorable to Mr. Durden that was withheld from trial counsel?
No, I don't. I don't remember. I couldn't say that wasn't at issue at the time, but I really can't remember that there being evidence. I mean, could you be a little more specific? Evidence that was withheld from Mr. Durden at the time of his trial?
Yes, sir. In particular, there's an allegation by Mr. Durden that the state failed to disclose evidence of conflicting statements or credibility issues of certain witnesses. Were you ever made aware of anything of that sort that you can recall?
I can't recall having that having occurred, but I couldn't rule it out. I mean, when we're talking about character evidence on witnesses, I am not aware. I can't say with certainty I'm not aware of anything that I thought was intentionally withheld.
And obviously, if you thought favorable evidence was withheld or had some information that favorable evidence was withheld, that would have been an issue that you would have considered and potentially raised on direct appeal.
Yes, and I have had an appeal where I've done that. So, yes.
Ultimately, were the issues that you did raise at motion new trial and then on direct appeal the ones that you thought had the most likelihood of success for Mr. Durden?
It was. They were.
And is that generally your strategy, to only raise the ones you believe have merit?
I try to do that because, I try not to throw in just everything and argue it under the same old stuff. I try to find something that is relevant that might have a chance of success.
Mr. Mills, that's all the questions I have. Mr. Durden may have some questions for you.
Mr. Durden, do you have any questions for Mr. Mills?
Do you not remember me asking you about the victim's father initially telling the detective that it was impossible that his gun was missing out of his safe unless it was stolen? And then I told you he showed up in trial and said that he did not remember that he told him it was impossible. It must be stolen. But then he found out his son was dead. He said he might have left that he did not know. When his initial statement was, the only way my gun is gone is if it was stolen, until he found that his son was dead. And I also alerted you about Alexa Blueball. Her initial statement to the detective, which is on cameras, there's no gun. There's no gun. He's lying. Shoot Jonathan Durden. Shoot Jonathan Durden. Then once the gun was found, she said, I was just scared. No, she concealed that gun and come in and there was conflicting statements by the witness Alexa Blueball and the victim's father. I cannot remember his name, his stepfather. But and also, okay, my trial attorney Jerry Muckins.
Mr. Durden, yes, you got to slow down now. You're here to ask Mr. Mills a question, and the question was, does he remember talking to you about conflicting statements?
I'm sorry, Your Honor. I was just bringing up the conflicting statements that I brought to his attention before trial.
Well, I think
Your Honor.
I think you gave him a good idea. So, Mr. Mills, do you have an answer to that question?
Yes, sir. I believe that what I remember was the possibility that there were statements made by additional witnesses that would be. That it might be good to interview some of these people on my own and try to find out or whether or not they had some conflicting testimony. But I can't remember if what we talked about was the specific things that you were just stating about hiding the gun and that kind of thing. I can't remember that part, but I do believe that when we were reviewing and when you were reviewing the transcript, you thought that there were additional witnesses that may have contradicted some of the statements. I do know, and I'm pretty sure that from the police reports and such, that those statements that were made, if they were made, were not contained within the evidence. if I remember correctly, but, I'm not sure. I think that was one of the basis for me originally requesting to try to get this continued so I could investigate some of these statements.
Right.
All right, Mr. Durden, do you have any more questions for Mr. Mills?
Yes, well, I remember Mr. Mills did ask for additional time, so he had more time to view, and the judge, Sidney Morris, refused, said that they did not want to house me in Whitfield County because of my charges, and then they rushed it, but he did request time so he could review this, but the judge denied it. Yeah, I remember Sidney Morris denied his request. They did not want to house me in Whitfield County because of my charges.
I understand that. Do you have any more questions for Mr. Mills?
Would I have opportunity to ask him questions later, or I had to do it all now?
No, you need to do it now.
Okay. I mean, can I please have a few minutes just to think, because I'm very, very nervous, and I've received I have brain injuries, and I'm just very nervous, sir. And can I just have a few minutes to recollect?
Well, Mr. Durden, you've had over 5 years, but anyway, I'm going to move on, Mr. Durden. Do you have any more questions for Mr. Mills?
I guess no, Your Honor. I'm just so nervous. My mind's blank right now, and I'm so nervous.
Well,
Understand that. All
if I
right.
may elaborate a little bit on his previous question, Your Honor, concerning that continuation, I know if you'd allow me to, I don't
Go
know
ahead.
if it's.
Go ahead, Mr. Mills. Go
Okay.
ahead.
The other reason, the main reason for that continuation that I had requested was that I could try to find out what was going on with the grand jury in that case. The process of the grand jury was a little bit unusual, and there were specific information I think that I was trying to obtain about when certain grand jurors were sworn, when they weren't, whether or not the grand jury was dismissed. And that was one of the main issues that I had on appeal. That and the fact that Mr. Durden had brought up the questions about conflicting statements by these additional witnesses was the basis of my continuation, our request for a continuation at that time.
At that time, right. Mr. Daniels, do you have any follow-up from Mr. Mills about this grand jury issue?
No, Your Honor.
All right, Mr. Durden, it's your last chance. Any more questions for Mr. Mills?
About the grand jury issue?
Well, any questions at all?
I don't know. I mean, can I ask him legal advice for him being my former attorney?
No, sir. You can't do that. He's not your attorney now. All right. Well, I'm going to move on, Mr. Durden. Now, again, you're going to get a chance to file a written brief, Mr. Durden. You can brief these issues later, but I'm going to excuse you now, Mr. Mills. Thank you for your time, sir. You are excused. You may terminate the connection and go about your business.
All right. Thank you, Your Honor.
Thank you, sir. All right, Mr. Daniels, you have anything else?
I have Respondent's Exhibit A, which is a complete copy of Mr. Durden's direct appeal to the Supreme Court of Georgia records, including the trial court records, as well as the briefs and opinion of the Supreme Court of Georgia.
So admitted, Mr. Durden, you'll get a copy of all of that. It'll be delivered with this transcript to you at Telfair State Prison. Once you do receive it, you will have 30 days to file a written brief where you can brief anything you want to brief that's set out in the transcripts. So you'll have 30 days to do that. Once you receive it, Mr. Daniels can have the same opportunity. And once all of that gets filed, the court will then make a ruling on your application for writ of habeas corpus. Do you understand all of that, Mr. Durden?
Yes, Your Honor.
All right, very good. Well, that will conclude the proceedings for today. The evidentiary portion of this hearing is now closed, and you'll get I'm not going to promise you an exact date, Mr. Durden, but it will be with all deliberate speed, and then you'll have the opportunity to file
2030, 2050. It'll be with all deliberate speed in Georgia, means freaking never. Anyway, I don't, I'm not hoping they win. I'm not hoping either of those inmates win this habeas that they brought in front of this judge today. What I'm hoping is they get a fair shot of what our Constitution gives every citizen. That's what I'm hoping. And it doesn't sound like they're going to get it. I mean, it doesn't sound like it. It sounds like, if you want anything in Georgia, you have got to hire an attorney. And if you don't have money, forget it. You're just going to sit in jail for years. Okay. We're going to go to Judge Ponda. We're going to go to Eric.
Except an out-of-county Denver case.
It's funny because I would never call Judge Fleischer by his first name, even if we're like out at dinner, and he's sitting beside me and he's like, "Hey, we're out. Call me." I wouldn't. I wouldn't. But this judge, you know why this judge is Judge Eric to me? Because Johnson is just such a common name that Judge Johnson could be anybody. It could be Georgia, could be Michigan, it could be, you know what I mean? But this is Colorado, and this is Eric Johnson, and he's one of our favorite judges. So I didn't want his name to get lost in all the Johnsons we hear. So it's Eric. I can't remember if I need to fast forward through this first part or not, so I'm not going to. We'll be all right.
Even for third-degree assault. He does have 5 days of pre-sentence confinement credit. We are asking the court to award that towards that sentence. And as I mentioned, I am asking for 180 days with work release authorized and a stay. And perhaps the court could set a review date. I think his application, from my understanding, will be processed in the next several business days. So I would request a stay until next week, perhaps Friday, just in the abundance of caution, because if the court sets on Monday, then I don't want to be in a position where I'm asking for another continuance. But the application has been submitted. And as I indicated, there's nothing to suggest that he will not be accepted into that program.
It's nice that we get an early ponder, right? Or are they waiting for him?
Prosecution have anything?
Your Honor, court heard the effects that this has had on the mother of the two victims in this case and the two victims themselves. He essentially got into a fight with his 6-year-old and 8-year-old children. He was certainly, from everything that everyone can see, heavily intoxicated. As the defense stated, that's not an excuse. The plea in this case was essentially an attempt to avoid certain consequences the defense was concerned with, while trying to get the justice or the penalty that the victim and the family thought was appropriate in this case, which is the purpose of him doing time. He, as stated, did have a prior case with the mother of his children, in which case he was given a deferred judgment. He was successful on it, which is semi-hopeful that he'll be successful on this probation. However, the fact that he then years later is coming here on a separate case, success is more than just the time period for which you're in probation. I do think that it is 100% appropriate for him to have monitored sobriety and to have alcohol evaluations and treatment as a part of his probation, based on the allegations in this case and the allegations from the mother of the victims. He's getting a benefit here based on avoiding those other consequences the defense were worried about. And kind of in exchange for that, the jail sentence here is appropriate. The people are asking for the 364 days. There is no restitution in this case.
Sir, you have the right to tell me anything you'd like me to know before I sentence.
Just that I'm very sorry, sir.
Council approach.
Council approach. I don't remember this happening. Hold on, let me bump it up. You're going to hear Judge Eric in a second talk, and he's really good on this one. He's a good one.
Mr. Flores, it seems like everyone's looking out for you except you. And what I mean by that is your attorney is busting his rear end, getting you an exceptionally good disposition. And the DA, in the exercise of their discretion, is giving you an exceptionally good disposition when, given the prior DJ, they had every reason and ability to say, I don't care about those consequences anymore. You had a chance and you blew it. Now it's no longer up to us. This is about you and your actions. But they didn't do that. So now you're in another golden position. I am not going to play around with this case. I am going to be suspending. You're going to get your 3 years of probation as part of the agreement, but I'm suspending 3 years in the Department of Corrections. Because if you mess up, if you fail to remand, if you do anything to violate this probation, I'm putting you in prison for 3 years. You understand?
Yes, sir.
So you better not drink at all, because a condition of the probation, yes, there's substance abuse evaluation, treatment, but it's not just no drinking to excess. It is no drinking, period, for 3 years. You drop a hot UA, I'm putting you in prison for 3 years. Why am I being hard? Because if there is a situation where a court ought to be more paternalistic, crimes against the elderly, and crimes against children. And you see how seriously the federal government considers child abuse. So you're lucky you avoided that. I am going to sentence you to 364 days in the county jail as a condition with work release authorized. You are to remand on August 15th by 9 a.m. up in Larimer County. If you do not remand, I will issue a warrant for your arrest, and you will get 3 years in the Department of Corrections. Do you understand that?
Yes, sir.
I'm also going to set a review date here for August 18th. It can be a paper review, or counsel, if you want to appear remotely, just let me know that he's actually turned himself in. Prosecution, you can confirm, make sure that we know what's going on. You need to report to Denver probation now at 303 West Colfax. It's just catty corner from here. Get probation started, get that going, let them know that you're going to be remanding for your work release jail sentence on August 15th. Anything else from the prosecution?
Not from the prosecution. Thank you.
Defense?
No, thank you.
Any questions, sir?
No, sir.
All right. If you fail to report to probation today, I'm putting you in prison for 3 years. So go right now.
Yes, sir.
Oh, Judge Eric is a little bit irritated with crimes against children, guys. So, good job, Eric. All right. More of him, please. This judge? Is that what you're saying? I wasn't paying attention because I was trying to get my OJ stream set up. I'll play him later if I can find. This is like a 4-hour docket, and I just played 11 minutes of that. So I don't really have anything prepared for the special live stream today. Remember, we're doing that special live stream in about 6 hours, 7 hours, right? And I'm going to give away 60 memberships to thank you guys so much for watching and supporting me. I really, really, really appreciate it. So come back today later and make sure that your gifting is on, turned on. And if you say something in chat, I think it bumps up your chances. But again, I don't know. YouTube rules are a little weird. But I don't know. If you want a membership, I would say something in chat because I think it does bump up your chances. I don't know. I don't pick who gets the memberships. Just YouTube just gives them out to people who are subscribed to my channel. I think. I'm 82% sure you have to be subscribed to my channel to get a membership, but and then I'm also 18% not sure if they could just give them to anybody in the world. So I don't even know. CJ won't make it, but CJ will be here in our hearts the entire time. But like I was saying, I don't have anything prepared for this live stream because this is not going to be a scheduled no, that's not the right word. This is not going to be a time and place where you are going to come to watch a court video. I will be playing court videos in the background, but this is a thank you to you guys. This is a chance for us to talk, and we're gonna frickin' pause, and we're gonna talk to people about their cat, and we're just gonna be happy, that we can just talk to each other. We have great friends in here. It's just going to be a nice live stream for us to laugh and, hang out for an hour. And there will be videos on in the background. Don't tell JK that, though. It's probably going to be this guy for 1 hour, probably, because what the heck? Why not? I mean, doesn't matter. we we are the content. We are the chat is the content, and it will be for that hour. So um also if you haven't watched this one yet, I just changed the name of it. This lady absolutely loses it and screams and yells and has a fit. If you haven't watched that video from yesterday yet, go for it because it's one of my favorite videos of all time. It's the lady with the big black eye. That's the one, big black eye. That's the one. And that you can watch the whole video, and I think I might pause it once. I'm not sure. I can't remember, but it was for a good reason. All right. OJ's not set up yet, but will be before this outro finishes playing. So thank you so much for coming out today, guys. I really appreciate it. I hope to see you again really soon, and I hope that you are the one that gets the gift membership. Because after I do this membership thing, maybe tomorrow, I don't know, I'm going to do a special live stream just for members only. And, we're going to have fun. So have a great night, guys. I'll see you again soon. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no